Well, good afternoon, everyone, and welcome to today's webinar, which is Up in Smoke, Navigating the Haze of Marijuana Policies in 2025. In case we haven't met before, my name is Holly Foxworth. I'm a registered nurse. I'm also the Director of Marketing and Communications here at Axiom, and I'm thrilled that all of you are joining us here for what is always every year our most popular webinar, given the topic that we'll be discussing here today. But we know it's hard to keep up with all the changing laws. You're trying to balance compliance, you're trying to balance safety, all while you're also trying to address hiring concerns at the same time. So that's really our goal today, is to cut through some of that haze, give you some clear, practical guidance that you can implement on how and navigate some of these changes. So we do have an expert panel that is joining us today. First up, we have Dr. Scott Sherry. He's our Chief Medical Officer here at Axiom Medical. He's going to be walking us through the medical and safety concerns that surround workplace marijuana utilization. We also have Phillips. He is an employment attorney with Ogletree Deakins. He's going to cover the latest legal developments, what you need to know about some of those state laws. He's also going to go through the off-duty use protection and then also some of the compliance pitfalls. And then Dara Wheeler, our Chief Marketing Officer, is back with us again. She's going to be sharing some shocking results here, some of the trends that we're seeing in drug test cheating that have came up within this year. So she's also going to be sharing some employer case studies and giving you some ideas of other organizations that have really taken a look at their THC policies and made some adjustments there. So really good stuff to come here today. Let's go ahead and take a minute to look at your screen and kind of focus on what you have going on there. What I would bring your attention to is on the right-hand side at the very top, you should see a blue box there, and that is your ticket to next month's webinar. So all that you need to do, there should be an RSVP button that's right below that. You just need to press that button. It'll get you registered. You don't have to enter any additional information. We'll go ahead and send you over a calendar invite and you'll be set for this next month. So be sure and take care of that. We are shifting gears. We're going kind of from workplace policy to actually wildlife hazards as the springtime approaches here. And so we're going to be going through venomous threats, safeguarding against springtime bites. So that covers everything from snakes to spiders to scorpions, you name it. We also have the infamous Emily Roberts that's going to be joining us from Snake Discovery. If you guys are not familiar with her, she's kind of a big deal. She has over 3 million subscribers on YouTube, and their story follows their over 100 reptiles that they have at their organization. So she's extremely knowledgeable. I always learn something from her every single year. Mind you, I didn't say that I don't jump still every time that I see a snake or spider or scorpion or stand in the chair and wait for my husband to rescue me. But it definitely does help to not only have the information about how to prevent exposure to some of those types of bites, but also what to do in the event that you or any of your employees were to be bit. So that gives you some really practical knowledge there, not just with the proactive, but also reactive. So be sure and join us for that. Again, that's going to be on April the 17th, and that will be at 1:00 p.m. Central. So now let's travel to the bottom of your screen. And so that is where you'll see the Q&A box. That is where you're going to have, we're going to be doing a lot of engagement. So that is where you want to go to receive prizes, to receive gifts. That's where we want to hear from you, anything that you want to share. If you have questions, if you have insights, if you have challenges that your company is maybe faced with some of the policies that you have that are going on right now with your marijuana policies, if you've maybe encountered an impaired employee, if you have any stories, tips and tricks, anything that you want to share, please do it right there in that box. Obviously, if you have some questions that come up, this is a judgment-free zone. We will assume that everyone is asking for a friend. So definitely don't worry about any of the questions that you have. We're not judging you for those, and maybe we actually don't even have to say your name if that would make you more comfortable. So be sure and utilize that box. That is where I go to give out gifts after these events. So I definitely want to hear from all of you there. Lastly, we do record these sessions. So normally it takes around 24 hours, and then you'll get a link back that will give you a replay of this should you want to review it it, or you can share it with any of your colleagues there as well. So we do also have some links there to some of the blogs that Kate has written for us this last month. So those are great as well. So let's go ahead and meet our participants. I think that that Tay is on a call and should be joining us here momentarily. So we will start with Dr. Cherry, and then we'll go on to Dara. Dr. Cherry.
Thank you, Holly, and thank you everyone for joining us today. My name is Scott Cherry. I'm Axiom Medical's Chief Medical Officer. I'm a board certified preventive medicine and public health physician. I've been supporting the military, industrial, and corporate operations for the past 20 years, and it's a pleasure to be with you today.
Thank you so much. And Dara Wheeler.
Thank you, Holly. Welcome everybody to a really interesting topic. This is, like Holly said, always our most popular and most attended webinar of the year. I do encourage you all to use the chat and let us know what you're doing or any stories that you've had. And we'll talk a lot about how companies are handling this moving forward into 2025.
Absolutely. Well, thank you, Dara. I appreciate you joining us well. And Tay will jump in on us momentarily here. But to just give you an idea of what we're going to be going through and talking through today, we're going to start with we'll take you through some of those legal updates that you're going to need to know. We're also going to take you through some of the medical and safety concerns that come up anytime that you talk about having workplace and marijuana in the workplace, and then finish up with some employer strategies for how it is that you may want to not only review, but you may want to look at revising some of your workplace policies there. But at a minimum, definitely reviewing those on a regular basis. So before I kick us off and send it over to Dara to get us started, I'm going to ask you your first poll question here. And remember, guys, you're going to be utilizing that chat bot at the very bottom there. So this is your first poll question. The person that gets closest to the number is who will give this to, but think large. So here's the question. How much do you think that workplace drug test cheating has increased in the past year? So what we're looking for is a percentage increase. Do you think that would be 25%? Do you think it's 50%, 100%, 500%? Give us an answer on what you think that would be. Just put it right there in the chat box. Again, that's how much do you think that workplace drug cheating has increased? Ooh, lots of good answers that are coming in. Lots of good ones. Ooh, I saw it 200%. So how much do you think that's increased in the past year? Dara, do you think they're going to be surprised with what they see?
I think so.
I think so too.
Ooh, somebody got close, I think.
Ooh, so they did get close. They did get all right. I think we'll call it the one that was over 300. Do you want to say that I think that's what we'll call it there.
I think I saw it over 600.
There was a 500. Okay, the 500.
Hold on. George had 600%. I think George was the first with 600%.
All right, George, you took it home then.
Eric was first with 600.
Maybe we just need to send a gift to both of them. All right, here we go. So, Dara, you ready to reveal what percentage increase this is here?
I am ready to reveal 633%. So,
wow.
Alex sent me this number, and I asked her to check again because I didn't believe it. But what we're seeing is information on how often we are seeing issues with tampered samples or people using finding out that they're using ways of tampering with the testing. So it's a 633% increase. So it's not that every test has been tampered with. It's just a big increase in people trying to cheat drug testing. What this is showing that we are in a place with shifting beliefs and approaches to marijuana use and how to handle that in the workplace. So most of us grew up in a time in corporate America where there was a zero tolerance policy. And so historically, zero tolerance has been very much the approach that if anybody is using any substance while at work, there is this zero tolerance approach. So with some of this data that we're sharing, it is shocking, but it's also understandable that that we have had a big shifting landscape in what we're dealing with here. Dave's here. Hi, Dave.
Hey, late for the party.
How are you?
All good. We'll pause in just a second and let you introduce yourself.
No, you're good.
We're just shocking people about testing right now. So employers are looking at reevaluating their policies and having to manage a shifting approach because it is moving quickly. So we know that there's obviously some, and Tay will go into the legal landscape of marijuana use, but more states are legalizing it. The testing policies are struggling maybe to keep up. And then it depends on the industry and hiring, and there isn't really yet a way in testing to determine current impairment. And we'll talk a little bit about what that means. I know Dr. Cherry will talk a little bit about how to determine impairment, what that looks like. But that is the landscape we're jumping into. But I will stop and let Tay introduce himself.
Yeah, no, thank you very much. And I'm sorry, everybody who's on. I tend to be jumping from thing to thing, mostly because of this administration, all this sort of chaotic stuff going on, which is actually a little bit of a reprieve from talking about drugs and pot all the time, sort of in a weird way. But it's nice to be here. I guess let me tell you a little bit about me. So I am at a law firm called Ogletree Deakins. We are a technically international labor and employment firm. We've got, I don't know, I lose count, 1,000 or so lawyers, 58, I think, offices. I voted earlier today to approve another one, so maybe it's 59 now. But we've got 59, 60 offices here, there, and everywhere across the country, and then internationally, 1,000 or so lawyers. And when it comes to labor and employment, that's a very, very broad, very, very broad description of I think what we do. And I think that sometimes people don't realize just how broad labor and employment law is. So it encompasses any and everything that happens within the workplace, right? Including workplace drug testing, workplace marijuana issues. And I guess my claim to fame is that 10 years ago now, was involved in the very first really big national medical marijuana case that had ever been filed in the United States. It was filed in Massachusetts. And it was, I'll give you the short version. It was a disability discrimination lawsuit involving a medical marijuana cardholder who had been terminated from her job. And so it was a somewhat landmark case because it was the first big national medical marijuana claim. And so that's where I sort of started to develop this expertise in workplace marijuana issues. And it's sort of taken on a life of its own over the last 10 years. I would say that in the course of any given day, I probably spend at least half of my day talking to clients of all shapes and sizes, right? Big manufacturing companies, small mom and pop staffing companies, big healthcare companies, medium-sized banks. It runs the gamut of all types of employers about drug testing issues, marijuana issues, and all points in between, right? And I missed the first few minutes of this, obviously, but I think it has really become one of the most challenging issues in the workplace because it is one of these weird topics in employment law where morals and the law tend to collide a little bit. And because there is, and I think that somebody else will get into this in just a second, there is a little bit of a disconnect as it relates to what testing tells us versus things like impairment and certainly the look back window of detection for testing as well. So I will just say to you, this is a really convoluted, really difficult topic and one that really presents a lot of challenges for employers. So that's a little bit about me. I sit in Birmingham, Alabama, which is weird because it's not exactly the hub of liberal policies in this world. So it's odd that I know so much about this topic, but it's glad to be here.
Tay, we appreciate you joining us today. You always bring a wealth of knowledge. Last year, whenever we had you, there were so many questions that came through, and you were so helpful in addressing so many of those. So we appreciate you joining us again this time.
Yeah, no, thank you. And by the way, I'm sorry. If anybody does have any questions that they want to ask me, you're welcome to email me. I will answer all of them. I promise you I won't send you a bill in the mail. So if you have any questions, feel free to email me.
Fantastic. Thank you so much. To answer some of the questions that came up whenever we were talking about when Dara was revealing some of the, and when we were having the discussion about the percentage increase, some of you had asked, does that include, diluted samples? Does that include, what all does that include? And is that just the U.S.? So that is the U.S., the entire workforce. And that information actually comes from Quest that performs the majority of all of the drug and alcohol tests that are done in the United States. So that is, so they definitely have lots of data that they pull, and they produce a report every year. And should you want access to that report, it contains a lot of great information. You can access that there on the internet, there on their site, and it gives you a lot of information in terms of not just the pre-employment piece, but it also talks about some of the post-accident trends that they're seeing as well. So you may want to take a chance to take a look at that. Well, Tay, now that you're here, talk to us then about kind of the legal landscape this year that we're looking at in terms of where marijuana is legalized and what we're looking at.
Yeah, so this is a really good graphic on the screen that shows the states in blue are the states that have currently only medical marijuana legalization laws. Now, the states that are in green, those are states that have legalized marijuana both for medical and non-medical purposes. Sometimes we call non-medical recreational use. And then the states that are in white, or I guess sort of like a cream color, those are the states that do not have any marijuana legalization laws at all. And I think the legal landscape as we move into 2025, I think there's a couple of things we need to be very mindful of. Number one, we are starting to see more states legalize marijuana for recreational use, right? So we tend to see sort of a left to right and a top right to down movement when it comes to recreational marijuana use. And so there tends to be more states that have legalized marijuana for recreational use. And I think that's going to continue to grow. So in 2025, the state of Pennsylvania is probably the most likely state that will legalize marijuana for recreational purposes very soon. I think that you will see, and actually there's a couple of states here that actually need to be able to, because Minnesota has a recreational marijuana legalization law. Ohio has a recreational marijuana legalization law. So just the continued march towards recreational use, I think, is one thing we'll see in 2025. But if you were to pick a state that's going to legalize recreational, it would be Pennsylvania in 2025. I think the other takeaway, both from this map and also into 2025, is the expansion of medical marijuana legalization into your more traditional red or conservative states, right? So you start to see a lot of the southeastern states, for example, historically conservative, they have begun to pass medical marijuana legalization laws, right? And so I would anticipate that you would see the Tennessees, the South Carolinas, the North Carolinas start to entertain medical marijuana legislation. North Carolina, I think, would be the most likely candidate to pass a medical marijuana law next. So I think that could be on the horizon. Kentucky, another traditional conservative state, they passed a medical marijuana law that went into effect on January 1 of this year. So that, again, starts to show you the way that this tends to move. And then I think the last takeaway that I would say as we move into 2025 is, will there be some sort of an effort or a push from the federal government to not legalize marijuana? Okay, I want to make it very clear. I don't think that the federal government's ever going to straight up legalize marijuana, but will there be some sort of a push to perhaps move marijuana down on the list of controlled substances? So currently marijuana is listed as a, air quotes, Schedule 1 controlled substance, which means that it's on the list with all the bad stuff, right? The cocaines, the heroines, it's on the list of substances that we deem to be essentially the worst substances and covered by the Controlled Substances Act. So that's where it's at now. On the back end of the Biden administration, there was talk and proposals and a push to move marijuana down to Schedule 3. All right. So Schedule 3 is where we find things like ketamine. It's where we find things like Tylenol with codeine. So there was a push to try and move it down. That didn't mean that marijuana was going to be legal. It just meant that we were going to move it down to a less restrictive schedule. Who knows what this administration is going to do. I suspect that that will probably, and you don't need to read any political fandom one way or the other into that, but I would suspect that any efforts for anything that happened under the Biden administration is all going to get kicked to the curb under the Trump administration. So I think that efforts to move marijuana to a different schedule are probably going to go by the wayside. So I think those are really the three things that I would say as it relates to the legal landscape. Again, just to recap, more states legalizing pot for recreational use, more conservative states starting to move towards medical marijuana legalization, and most likely an abandonment of efforts to move marijuana down the list of controlled substances.
Okay, well, thank you for that, Tay. Dr. Cherry or Dara, anything that you wanted to add to that piece?
Yeah, something that I would just kind of follow along with this scheduling of controlled substances. So I definitely appreciate what you're saying, Tay. And I think what we're seeing now with this map that we're showing with medical marijuana use and how the federal government categorizes marijuana. So the way I view Schedule 1 is there's no no official medical use of Schedule 1. So the federal government's view of marijuana is in direct contradiction to the state's medical marijuana use policies. So I think every employer still needs to decide what's right for them. But right now we do have this kind of very contradictory framework between the states that do have medical marijuana use to the federal government. And I'll use some examples of like DOT and military that are kind of lighthouses across the continuum of gray area. But, I think this topic is one of the most important ones to have a multidisciplinary approach between medical, legal, HR, safety, risk, and, really having someone like Tay that knows the employment components of it, whereas you still may have a legal representation within risk, but risk having a different perspective representing the company's own risk tolerance per se. So again, those are kind of my initial comments.
Yeah, definitely. There was a lot of comments that came in that were talking about some of the challenges that they were facing, even if their state had not legalized that, but they were surrounded by states that had legalized it. So I can imagine that there's a lot of gray area there, and a lot of questions that come up and challenges that are faced. We did have one that was asking about what the cons would be, Tay, of actually moving marijuana to that Class 3 versus the Class 1. Are there any cons that you would say would be related to that?
That's a hard question. I mean, let me answer it a different way. The pros of moving marijuana from Schedule 1 to Schedule 3 is that it would then be deemed to be a substance that has, and this piggybacks on what Dr. Cherry just said, it would have a medically acceptable use and purpose. Yeah. And so I think that would probably then result in, frankly, I'll just say fixing a few of the practical problems we have with marijuana, right? I think that you would have FDA regulation and oversight, which means that you would have substance, and I know I'm giving a lot of faith to the federal government here, but for FDA oversight, meaning that we would actually know what's in a lot of these substances, right? And we wouldn't just have sort of willy-nilly whatever, Bob Smith who's growing this in, his backyard or whatever. So I think that would be helpful. And I also think that if we could have it be actually prescribed for medical use, I think that would be helpful, because then we would have the ability to have a prescriber, a prescription, a pharmacist who is filling the prescription, because I think one of the biggest misnomers with this topic is marijuana is not prescribed. You have a medical card, you go to the dispensary with your medical card, you buy your pot. And so there's no prescribed dosage, no prescribed regimen. And I think that's a little bit of a blind spot. So I think those are the pros if we moved it from 1 to 3. I think the biggest con would be that it doesn't legalize the substance, right? So there would still be this very difficult challenge, not only legally, but also, frankly, like morally and opinion based as to whether or not we should or should not be either zero tolerant towards it or laissez-faire towards it or somewhere in between. So I think that if it moved from 1 to 3, there could be a little bit of confusion from employers as to how they should treat it. And I think that would be the biggest challenge. So I think probably Schedule 2 is the right place to put it. Nobody asked my opinion, but I do think that the biggest con would be it probably would create more confusion. And this is already a confusing enough topic as it stands right now.
Absolutely. Yeah. Dr. Cherry, talk to us then about some of the trends that we're seeing in usage.
Yeah, so really just based on how things have been changing legally, socially in our country, we're seeing a massive shift in who's using marijuana in the workforce. And, before this change, a decade or so ago, there was maybe, some sectors that were more commonly seen as very passive about using marijuana, perhaps in construction, warehousing, just, unregulated or just certain workforces. But now we're seeing huge increases in, finance, real estate, public sector roles, for instance. And probably what's the real concern is that post-accident drug testing, drug test positivity has dramatically increased over the last decade, with over a doubling, 114% increase since 2015. So now we're at about a 7.5% post-accident drug test positivity. So for every 100 accidents that have a drug test, 7 are detected to be positive. And so this really raises serious question about how employers balance safety with the changing marijuana laws.
Certainly.
And really good. I see a ton of questions, and I know that people have a lot of questions about this. Certainly lob any you want to lob out there, but if anybody has any questions, like I said, put them in the chat. I promise you that I will, from a legal standpoint, if they're employment, law related, I promise I'll answer all of them if we can't get to them. Darry will send me the little spreadsheet or whatever, and I promise I'll reach back out and answer all of them. I promise.
Absolutely. We appreciate you doing that. One of the other things that's came up several times here in the chat too is the subject of CBD and how that some of the gummies that are associated with that, and whether it's okay to take the CBD versus something that has the THC in it. So it does look like that there's a lot of confusion that is still going on in terms of what people know that they're taking at the same time. So I would assume that would definitely present a huge challenge as well. Talk to us then, Dr. Cherry, about some of the impacts then that it has.
Certainly, there's studies on marijuana users, and they show that those users experience slower reaction times, reduced focus and concentration, lower problem-solving abilities, and increased errors in workplace accidents. And so you really have this kind of synergy of increased absenteeism and presenteeism, where people are more likely to miss work and have a much higher unexcused absenteeism rate. And then when people are at work, they may have much lower performance due to the cognitive effects of the THC. And so, I think sometimes we see this in alcohol and marijuana, where there's someone who's high functioning under either substance, but still, I think the user has a lack of insight into what's actually affecting them. And so there still is an issue with memory recall, task switching abilities, slower multitasking. And then I think the most concerning thing is situational awareness and missing safety hazards. And so Employers really need to focus on this, especially as the landscape dramatically changes about what's considered legal or moral in our country. This was never an easy topic, but it's much harder now as our country is seeing it become more legal, quote unquote, but it still has dramatic impact into workplace safety, especially workplaces that have safety sensitive work. And so, there is limitations in testing, but one thing we always focus on is really tracking performance-based reviews and tracking declines in performance. And is that a medical issue or is it something else? But performance-based reviews is really important across the board. In addition, adjusting accommodation policies for marijuana users is absolutely going to be critical now. I think, Tay, your landmark case that you brought up, where employees who have a legitimate card can quickly use the ADA or they're regarded as to having a disability, even if they're not requesting accommodation for a disability, can invoke the ADA. And so, and lastly, doing reasonable suspicion training for supervisors to educate them about recognizing impairment and having that tool at their disposal when needed.
Absolutely. I think that we had a comment that it came through just a while ago that had said that they had put all their managers and supervisors through reasonable suspicion training. And I just applaud that effort. I think that's exactly where you need to be. There were a lot of questions then, and it actually takes us right into this about some of the challenges then and some of the dilemmas that we have with testing. So talk us through those, Dr. Cherry.
Yes, certainly. So, marijuana testing is much more complicated than blood alcohol testing. And so some of the biggest challenges for employers is that a marijuana test cannot measure impairment or highness. It's really just measuring the active ingredient in the body. And unlike alcohol, which has a blood alcohol concentration standard, there is no universal threshold for the active ingredient in marijuana called THC. And so therefore, I think some of the legal challenges are that, or actionable challenges through HR, is that a positive test does not mean the employee was impaired at work. So for instance, if you're doing urine testing, someone may have used marijuana within the past 30 days and still have a positive test. With blood, it can be up to 7 days, saliva, 24 hours, and then hair testing can detect it up to 90 days. So, someone who's kind of a new user or not a chronic user, if they're using marijuana, they may be impaired for a few hours up to half a day. If they're a chronic user, then they can have, delayed effects for beyond a day. But the testing may be positive for many days beyond their impairment level, regardless of the level of use. And so there's, potential oral fluid testing, which has a better detection window. And then something that, I like just very functionally is having impairment testing, which can monitor cognitive and motor function in real time. And then, of course, what we just spoke about with reasonable suspicion testing for performance-based evaluations, moving towards a for-cause fitness for duty assessment.
Mm-hmm. Absolutely. Let's see. We've got so many questions that are coming in. Let's see. Michael had said, I hear that all the time, but I've tested team members and they tell me I had a joint yesterday or over the weekend and nothing. Why is that? That's an interesting result. I've never heard it go that way. I've heard complaints that they hadn't used in a long time and they were still showing up positive, but I haven't seen the reverse of that. Are you familiar with that, Dr. Cherry?
Well, there's a lot of individual variability. So the active ingredient THC is very fat soluble. So like when we think about how a substance is integrated into our body, you have most things are water soluble and then some things are fat soluble. water soluble, your body can get rid of pretty quickly. Fat soluble takes longer. So if someone has not a lot of fat on them, they may not actually retain a lot of the THC to where they're going to test positive. And if someone has a lot of fat on them, then they may actually have the opposite. But there's a ton of things, and like what Tay brought up too is the concentration of THC in the different marijuana products greatly varies, and so someone may actually have a fairly dilute exposure to marijuana versus I've heard now some of the I think it's genetically modified strains are extremely strong compared to historical marijuana. So I think it's the concentration of exposure as coupled with the individual variability of the person's makeup.
Mm-hmm. Do you feel like that there is more of a move then towards different types of testing versus the urine specimens that we've traditionally seen?
Yeah, so in medical testing, it's like a balance between convenience and invasiveness, and so I think in general, urine is the most popular because it's the most convenient and least invasive, but it's least helpful in this case. So blood and saliva may be much more effective in obtaining the information we need to be actionable on.
Okay. There was also some tests about breathalyzers. I know that we've had that conversation here before. Are any of the three of you aware of any that are available on the market currently?
I'm not. I don't know if Dara or Tay have any new updates.
No, there was a company that had developed a breathalyzer. And the point behind the breathalyzer being that it had a very, very short detection period. So to Dr. Cherry's point, we have these different look-back windows of detection based upon specimens that are used. And the breathalyzer was intended to have a 2, 3, 4 hour-ish look-back window of detection. And to be clear, that doesn't prove the person's impaired, but then we get to use good old-fashioned common sense, right? If you are using within the last couple of hours, then you are most likely high, which means that you are impaired, right? So that was something that was out there. There was a company that had developed that technology. That company no longer exists. So I don't know if, the technology has been developed. So, I mean, I'm sure another company could pick that up and run with that. But there's a long answer to a short question. I'm not aware of any company currently that is pursuing that approach. And frankly, perhaps maybe one of the reasons because oral fluid, I think, has a short enough look back window that I think a lot of employers have used that as sort of their new short look back window type of test. But again, long answer to a short question. I am not aware of any current company that is utilizing a breathalyzer.
Dr. Cherry, we've talked a lot about testing options to determine impairment or not, but those are all options if you're a non-regulated, federally regulated company. So could you talk a little bit about requirements under DOT versus non a little bit?
Yeah, no, that's a great question. And I love to use kind of the extreme examples and where we have kind of a huge gray area here. So, the federal government obviously has marijuana as Schedule I. And so, the DOT is a federal program. And so the DOT for truck drivers and, any other federal regulated work industry like FAA has really a zero tolerance policy. So they actually don't care about impairment. They care about detection of the substance. So those are classic zero tolerance. So you need a negative test. And, so you might have random or even at time of hire, drug test. But, the random is what really I think helps with compliance to these programs. But, I think a lot of the truck drivers realize if they want to keep driving, they can actually do something on the weekend. And then even if it's like 5 days later or a month later, if they're tested positive, they're going to seek, there's going to be a negative human or personnel action,
But it's only approved for urinalysis at this point, right?
Correct. Yes. Yeah. So there's not any, there's no change from kind of the old school way we viewed drug testing.
Yeah. Cheap, easy to manage a program. And like you said, it's the threshold of like, how easy is it to access, to run large scale programs and get some results that people can live with.
Yeah.
Right. And, I obviously it's the balance between, personal freedom and risk tolerance. And so I think in many ways, you may feel good that there's a very strong policy for those driving, the 80,000-pound trucks next to you in your personal vehicle. Obviously that's a philosophical and personal view, but, the urine has kind of this 30-day window in general. So it can be fairly sensitive to detect use,
One person pointed out that you can do some oral fluid for some collection testing, it looks like. But it is restricted. So, the point is that there's a very different way of managing policy and practice depending upon if you have federally regulated employees versus a non-DOT company policy. And so I know we'll get into policy, but the point is there are very strict regulations on how you test for federal employee programs or federally regulated programs versus a company policy approach.
Right.
Absolutely. Yeah. Well, Darren, while you're there, why don't you talk to us then about kind of the employer impact and what we're seeing, some of the trends that we're seeing?
Yeah, I mean, right off the bat here, you're seeing that if you have a pre-employment testing policy, and depending upon your review of your policy, and if a lot of employers came from a zero tolerance approach across the board, and of course, company policy sometimes might not catch up as quickly as practice, and so I'm sure Tay and Dr. Cherry have experienced a lot of this, where historic policy needs a lot of up-to-date review based on changing landscape. I mean, the map we showed was already out of date, to people's point, that it's changing quickly. And so when we think about pre-employment testing, hiring practices, if you have a zero tolerance policy or you have a very strict approach to it, a lot of employers are struggling to hire employees. And I think in our comments here, we just saw a bunch of people said that not only are they having a hard time hiring, they're having a hard time retaining really tenured employees based on policy. So I think somebody said that they lost some really, really great employees. I think they had about 4 or 5 that just were let go because of a positive test. So when you think about this changing landscape, and I know we're not here to provide direct legal support or medical support, and I know we definitely recommend working with company legal teams and working with groups like Tay's group, because it is very complex, and you end up in a place where you need, especially these multi-state, multi-country organizations, need very very clear policies across the various states that they're dealing with. So some have shifted. We've heard from a lot of clients over the last few years that they've kind of gone the opposite direction. Instead of zero tolerance, they've kind of gone full tolerance. And so I think you're seeing kind of swings both ways. Now, it is very dependent upon the type of employees you've got. And so when Dr. Cherry and Tay have both talked about safety sensitive roles. And when Dr. Cherry talks about safety sensitive roles, these might be roles that are not federally regulated, but are safety sensitive. And so when you think about the purpose and the original thought process behind a drug and alcohol program, it was to prevent accidents and injuries and deaths and all of the other things that you might see in a workplace that has hazards. And when you think about drugs and alcohol, you're trying to prevent impairment on the job in these safety sensitive roles. And so this goes well beyond things that might not even be legal in the state. So alcohol is legal in most states, but that doesn't mean we should be accepting alcohol use on the job in a safety sensitive role, or that people come into work impaired. It also means that medication programs need to be adhered to as well if you're in a safety sensitive role. Just because you have a prescription for a muscle relaxer doesn't mean that you should be taking the muscle relaxer before operating a forklift. So when we think about these things and these programs, marijuana has gotten a lot of attention because of its shifting kind of, we talked moral legal landscape in the United States. But these are programs and policies that affect many areas of the workplace and are becoming more and more complex as we think about the access that people have. So some companies have kind of gone the other direction. There are large companies listed here that have started doing no pre-hire THC testing, or have started relaxing policies based on state regulations, or changing the way they think about the pre-employment or post-incident testing approach.
Mm-hmm. Some of the trends that we were seeing as well that we were reading about were that some were actually keeping some of the pre-employment, but they were just removing the THC component out of that screening panel. Are you familiar with that, Dara?
Yeah, well, I'm non-DOT policies. You kind of see all over the place the way employers pick and choose what substances they're testing for, how big these panels are, and a lot of it is cost restrictive, or it's not just policy restrictive, but it depends on how to implement and manage. It becomes pretty complex. And so the more you test for, the more likely you are to have positives and have to have a workflow to deal with that. And so that's why the employment law workflow and conversation becomes really critical, because of the way you manage those cases, the way you manage people's accommodation requests. All of those things come into play when you start thinking about a policy, a role, and then how a company handles the positive. So that's why I think a lot of employers have kind of swung the other direction, where they're almost not testing at all, because it's hard for them to deal with the aftermath of what to do in those situations.
Mm-hmm. Really good points. Well, Tay, we're going to come back to you. I will ask the audience then, just kind of your thoughts. So, do you think that we should eliminate the THC in the panels, the drug testing panels? What are your thoughts there? And I'll let you guys answer in the chat. Tay, talk to us about some of the policy strategies and how it is that they can navigate through these different scenarios.
Yeah, and this is what I tell every client, because you will never hear me say a bad word about another lawyer, but some lawyers, and I will include myself in this sometimes, we just love to tell companies and clients what the law is, but we don't give them practical business-centric solutions. And I think that the challenge with this topic is this is not necessarily a legal issue so much as it is a business-centric and strategic issue that happens to have some legal issues buried within it, right? And so whenever I'm talking to clients about this, I always try and remember that I'm a business partner first and a lawyer second. And so going back to your question about policies and compliance strategies, the very first thing I tell every client when I'm talking to them is sit down with your stakeholders and answer this question. What do you want to do? What do you want to do? Do you want to keep testing for pot? Do you not want to keep testing for pot? Do you want to, be super zero tolerant? Do you want to be super laissez-faire? Figure out the answer to that question first, and then put together your policy, your procedures, build out your drug testing program. Do all of that second, but figure out what you want to do first. And depending on the answer to that question of what do you want to do, let's take it one by one, right? For your policy, you may want to have a super detailed policy that gets way deep in the weeds on any and everything in the world. You may want to have a super high level and generic policy that is very high level. That's my preference, is a super generic high level policy. Testing program. You may decide that you want to keep testing for pot for all of your employees. That's fine. You need to worry about what you're going to do with a positive test result and all the different legal issues that come along with that. But that's fine if you want to take that approach. You may decide you don't want to test for pot at all for anybody. And that's fine. Just take it out of your panel. And that's fine if that's what you decide from a business-centric standpoint. You may decide you want to keep testing your safety-sensitive employees, but you don't want to test your non-safety sensitive employees. That's fine. So there's a lot of different options in terms of how you test, how you set up your testing program as far as the who you test, the how you test, i.e. urine, oral fluid, et cetera, and the when you test, i.e. pre-employment, reasonable suspicion, post-accident, random. So again, figure out what you want to do with your testing program. And then I think you need to have procedures as to how things are going to work. That's not a policy, it's a procedure, right? How are we going to, for example, get people from point A to point B for testing? Who's going to be responsible for administering testing? Who's going to make decisions as it relates to whether someone is or is not tested? So I think those are things that people need to think about. And then frankly, I think that the most important piece of this, which is on the slide here and which we've talked about as we've gone along, if you are going to try and be zero tolerant, particularly towards pot, but even if you don't want to be zero tolerant, you just want to keep the workplace safe, I think that good reasonable suspicion training is the single most important thing that any and all employers should be considering doing. I do that training quite a bit. I actually have to do that training tomorrow for a client. I think reasonable suspicion training is hyper critical, irrespective of where you fall on the spectrum of zero tolerant versus laissez-faire, irrespective of where you fall on the answer to that question I posed of what do you want to do about marijuana. I think reasonable suspicion training is critical. And so I would encourage everybody on this call to think about implementing reasonable suspicion training. And I would think about how that training is going to be disseminated. All right. I think that if you're going to train managers, supervisors, employees, I think it's very important to recognize the audience that you are training. And that audience probably doesn't want to hear somebody lecture them on how they should be a police officer. I don't think that audience wants to hear about how they can become a detective. I think if you make it too complicated, then I think you're going to lose the audience. I always think that reasonable suspicion training should be focused on the process, right? So what do we do if we think someone's impaired? And don't worry about training them to be a doctor or a scientist or a police officer. That's too hard. It's too complicated. People are going to start looking at this thing right here and playing on their phone instead of listening. I think it's important to say, look, this is important. People can get hurt or killed. This is why you need to listen. We're going to train you on the process that you utilize if you think someone is impaired, more so than worrying about whether they actually are impaired. Let the test sort of figure out if there's something going on. But don't get too bogged down in being a detective or a police officer. So I know I went in a lot of different directions, but again, to tie it back to the initial thing I said, I think you need to first and foremost just think, what do we want to do about marijuana? What do we want to do about drugs and alcohol? And then go backwards. I think a lot of companies make the mistake of getting so concerned about what their policy is. I tell this to clients all the time, I could not give two craps less what your policy says. I don't care. You need to worry about what you're going to do in reality and worry about your policy later, right? The policy, I know companies like we love our policies, right? We over politicize things. We need a policy to go to the bathroom. We need a policy to go to make a cup of coffee. Don't worry about your policy. Worry about what you're going to do and what you want to do first, and then go backwards and figure out what your written policy says.
Tay, I'd like to just tag along to your reasonable suspicion comments. I think that's incredibly powerful because I think when people hear reasonable suspicion, they do think it's all of a sudden a law enforcement issue or along those lines. But the way I see it is it's a very generic approach to saying someone in the workplace is not performing to how we expect them to. And so most people do quickly go to impairment through illicit substance, but it can be also impairment through legitimate prescriptions. But there's also two other components that I think are missed. And one can be just an undiagnosed medical condition or a poorly controlled medical condition, which can be equally as impairing and maybe even concerning, especially in safety sensitive work. And then lastly, it can just be poor performance that's not medicalized or not due from impairment. And that's almost just as important because that's a performance management consideration, right? And so I think a lot of times people maybe refer to someone like me for a fitness for duty, and there's nothing medical there, whether it's substance abuse or a medical issue, but they still have that performance issue. So it still needs to be managed through a human resources type policy. So your view on reasonable suspicion, I think, is a great focus for our audience to be aware of.
Agree.
Sorry, real quick. It's similar to the way I train. I've done a lot of the reasonable suspicion training too, and it's very similar to the way I train in any sort of arena, HR or behavioral health, in terms of it's performance-based conversations. And as a good leader or manager of people, you need to have an understanding of typical baseline performance of your team and where it deviates. And so a lot of the reasonable suspicion training, like Tay said, it's not becoming a detective. You don't need to be able to know whether somebody is necessarily using on the job. What you need to do is pay attention to people's behavior and whether things are deviating. And I think sometimes we forget that at the base of what we're talking about here is performance management. And if you understand performance management, you don't have to be an expert in drug and alcohol testing. You need to be an expert in your team and understanding what your team's performance is capable of.
Excellent points. How frequently would you recommend that they're doing the training? Derek?
Gosh, I think once a year, just and then make it part of your onboarding for new hires. I mean, when I do this training, and it sounds like you know we all do this training, I think that we oftentimes encourage it to be recorded so it could be played for new hires. But I think, you know, there's certainly some legal strategy behind trying to do good reasonable suspicion training. I mean, I think good training creates good facts. Good facts creates difficulty for people to bring legal claims and or the ability to defend legal claims. But I think the one thing we all need to be mindful of is at the end of the day, it's all about just trying to keep the workplace safe. And so I think that doing that refresher training pretty frequently, just to remind everybody that this is all about, you know, personal and coworker safety, I think is really important. So top of mind, I think is good. So, you know, annually.
Okay. There was also a question that came through that was asking about, could there be an impact to work comp coverage if they remove THC from their panel, their testing panel? Any thoughts on that?
You know, it's a good question. So let me go backwards for any of you who are not on the call that don't realize it. And to be clear, work comp sort of varies from state to state, but by and large, if you have a positive drug test after a workplace injury, then that generally is going to create a disqualification for an individual to be able to receive workers' comp benefits. Not what you asked. It also includes a disqualification for unemployment benefits most of the time. So that's sort of the reality of positive drug tests after workers' comp injuries. So to go back to the question of would removing THC impact workers' comp claims or coverage, I think the answer is it would, only because you probably are going to not have some positive test results, because if you're taking marijuana out, that's the drug that's most likely, frankly, nowadays going to trigger a positive drug test. And so I think you will have an increase in workers' comp eligibility simply because you are eliminating a big disqualifying factor from that eligibility. Does that make sense? I don't know if I worded that well, but I think that if you remove THC from a testing panel, particularly a post-accident testing panel, then I think it would result in an increase in claims simply because there would not be the disqualifying factor of ineligibility because of a positive marijuana test. Now, this is what I tell employers all the time. This is where it gets really challenging for employers, because post-accident testing is a big-time gray area when it relates to the ability to defend these pot claims. And post-accident testing has historically been something that a lot of employers really hang on to because they do want to avoid workers' comp claims. They do want to avoid unemployment. They do want to try and create these mechanisms to decrease that liability. I caution employers all the time, if you decrease liability on the workers' comp side, you may very well increase your liability on things like disability discrimination claims for medical marijuana card holders. I'm literally sort of doing this while also responding to a client in California. They have recreational marijuana protections in California, so I'm trying to work through that issue with them. So I'm not saying that you should abandon your post-accident marijuana testing, but I do want you to be mindful of, you may very well knock out a workers' comp claim, but then create another legal claim at the same time. So a very long answer to your short question, but yes, if you take marijuana out of testing panels, you are probably going to have an increase in workers' comp eligibility.
Absolutely. Thank you so much, Tay, for all of your answers as well. Thank you to all the questions that have came in. There's quite a lot, so we will definitely be following up with you guys. But I appreciate everybody on the panel, and if you haven't already, make sure that you hit that RSVP button for next month's webinar, and we look forward to seeing you then. Thank you.